have 8 years of schooling versus my hour and a half when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do know the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature, to the extent that he's setting himself up or trying to set himself up for these objections. I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
Is this guy pretending not to understand what's going on? Or is he really this lost? Personally, I think he's putting on an act because it's hard to believe someone could be this unprepared while facing possible jail time. This isn't a pop quiz. You can't just wing it and hope everything works out. His entire argument falls apart when you realize he could have had a court-appointed attorney for free. But instead of accepting real legal help, he's chosen to file baseless motions and complain about only having an hour to study. What did he think this was? An open book test? Honestly, he reminds me of that student who clearly didn't do any research for their presentation, so they just start talking in circles and hoping nobody calls them out. But here's the thing. We all notice. What do you think? Is he faking it or just totally out of his depth? Let's jump back in.
And it states that as a federal law and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And you didn't want that either. So then we went through the hearings and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So This is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything
you gave me
you wish.
bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
I've got to say, the judge handled this really well. Sure, she could have shut things down a bit sooner, but honestly, watching it all unfold gave us a moment of comedy. Still, you have to wonder, what was going through this man's mind when he walked into court today? Did he actually think he was going to talk his way out of trouble while barely reading from a crumpled up note? This is exactly why it's so important to truly understand your rights, not to misuse them with made-up legal theories, but to avoid ending up like this, embarrassing yourself in front of a judge who has no time for games, even though the judge remained calm and offered a few parting words. The courts don't entertain arguments like his, especially not when you have free legal help available and still choose to ignore it. Honestly, it just made no sense. This was one of the most baffling defenses I've ever seen in court. He's the perfect example of what not to do in a courtroom. The legal system isn't something you can just rewrite to suit yourself. But hey, at the very least, we all got a little entertainment out of it today. That's it from me. What did you think of this guy's performance in court? Would you rate his reading level anywhere above grade school? I'd say that's being generous. Either way, drop your thoughts in the comments. And if you enjoyed this breakdown, don't forget to like and subscribe. I post daily, so if you have any court clips or cases you'd like me to cover, let me know. Thanks so much for watching. Take care, everyone!